Good morning. This presentation deals with council tax, Part 2. This is an extension to our first presentation, which had dealt with the legal arguments you could use against council tax, and in this specific presentation, we are going to deal with the paperwork which accompanies the summons. We are going to analyze this paperwork and see what deficiencies we can find within it. Before we begin, I must give you a legal disclaimer that the information presented here is current as of the time of production. However, it is your responsibility to ensure that the documents that are quoted here are current and up to date, and the paperwork presented here deals with Lancaster City Council and may differ in your area depending on your council. Ultimately, it is your responsibility to understand and make use of the information presented here as you see fit. The author and/or web hoster is not responsible for the actions you take and how you use or misuse this information. Ultimately, is your responsibility. If we look at the paperwork that comes with the summons, you will notice that it says HM Courts and Tribunal Services. This would give you the false indication that the paperwork actually comes from the court. However, HM Courts and Tribunal Services is simply a title. It is not the legal seal from the court. So this paperwork is more than likely fraudulent. Secondly, you will notice that it says the word notice on the top. So when we send our paperwork back, we will send them a notice. Letters can be ignored, notices should not. You will also notice on the first line, it says the persons named on the attached summons. So this document is just a run-of-the-mill cookie-cutter document, which has been sent out and is sent similarly to everyone. And it says from Lancaster Magistrates Court. When you take note on the document of the summons, it was actually issued through Preston Magistrate Court. So which court is it being administered from? Lancaster or Preston? And it says from Lancashire Magistrates Court. So again, we have another deficiency. And then it says read Lancaster City Council, and it gives you the contact phone number and the email. I would suggest that if you are going to respond to these people, you respond both via email, because it's instant, to both parties, and I would send it under the CC method of doing things, which stands for carbon copy. I would not use BCC, and the reason for this is that if you CC them, then both parties are well aware that the other party received the document, or documents as the case may be, and should one deny it, you can simply look at the email from one to verify the other. And you'll notice the other thing, it says here, subject council tax application for liability order to be granted against you. So what this is indicating, in this case, is Lancaster City Council is putting an application before the court in order to grant the liability order. So the liability order does not exist at this point. Now, if we look further down the page, on the second part of this document, it says attendance of the hearing is by telephone only. Please do not attend the court building. You should be aware that all court hearings are to be done in public. So the very fact that they're telling you to do this in private, they're already violating civil court procedure. And it says Lancaster City Council has summoned you to court for an unpaid council tax. Well, Lancaster City Council does not have the authority under the law to summons you to do anything. That actually has to be done through the court. So now Lancaster City Council has taken on the role of a court, which is a violation of the Government Act. So this paperwork is fraudulent. The summons is included with this letter. Well, this is not a letter, this is a notice, so they've obviously screwed that up too. And then it says, it means that they will ask the court to grant the liability order for unpaid council tax. So they're admitting that this is not a liability order. Now, a liability order means that the court agrees that you owe the money, and the court and the council can take steps to collect it. These steps could include seizing of goods or taking of money out of your wages or benefits. So sometimes some councils will ask you to fill out a piece of paper that indicates your means to pay council tax and or your ability. Now, a lot of times they're asking for your employment information, and I would advise you not to fill out that paperwork. Now, if I reread the last sentence of the first paragraph, it says these steps could include seizing of goods or taking of money out of your wages or benefit. The first thing that you should know is that you have an equitable claim to all of your goods. The municipality, the local council, does not, and they do not have the right to enter your property and take your goods. There is no warrant of control because you're not in breach of any contract, lease, or loan agreement with the council. As such, they do not have the legal authority to take your goods. So that means that this document now is fraudulent misrepresentation, which actually is a contempt of court. Now, if we read a little further, it says you have five options. Pay off the amount of the summons in full. This will end the case. Well, you can do that if you acquiesce that they are in fact owed council tax. And it says number 2, if you accept that you owe the money, you can make an arrangement with council on how you'll pay it, which is usually installments. If you make an agreement to pay the council, they will still ask the court for the liability order. So they're again indicating that this is not a liability order. It's an application for a liability order. Okay, and then it says further, but if you stick to the agreement, they will not take any other steps to seize your goods, etc. Well, they don't have the authority, as I've already indicated. To make the agreement, you should contact Lancaster City Council immediately to talk about it, rather than waiting for the court hearing. You can speak to council by calling. It gives a phone number and an email. It says if you disagree with the summons, which obviously is not a lawful summons because it wasn't issued by the court, or believe that you should not be liable, you must contact the council immediately. Please read the notes in the back of this letter. They tell you what the council must prove to the court and what defenses you have. This again is depriving you of due process of the law because you have any defense that you wish to enter if this in fact is a lawful hearing. If they're restricting your defense, then this is not a lawful hearing and the whole thing is an act of fraud. And we have a presentation that deals with legal maxims. And in one of those legal, or two of those legal maxims, it clearly states that fraud destroys all that it touches. And it also says that if fraud is the base of anything, the superstructure falls, which basically means if there's fraud, the whole thing's out the window. And it says if after reading the guidelines you still wish to discuss or disagree with the summons, please contact City Council no later than 12 noon on the day before your court hearing, shown on the summons, and it gives a phone number. Well, the standard court procedure is you have to have documents into a court 7 days prior to a hearing. So if you can automatically just contact City Council and this thing will be dissolved as long as it's done noon hour on the day before, this indicates again the council and or court are not following civil court procedures, which is yet another issue. Further down, it says if you're unable to agree, council will arrange for you to join the court hearing by telephone to explain your case to the court. Well, again, as I said earlier, you should not have your hearing in private. You should have your hearing at the court, and you should insist on it. If you don't insist on it, they will proceed on a telephone hearing because this way there's no record of anything. I would also strongly advise you to record your own court case, and you do have that legal right, contrary to what they will tell you. Now it says number 4, join the court hearing to explain your case. After reading the guideline notes, you believe you had a good defense and want to explain your case to the court, you may book a time to join the court hearing. The other option is do nothing, and counsel will ask the court to make the liability order in your absence. Now, I do not ever suggest that a person does not attend a court hearing for two reasons. First, if you do not attend a court hearing, they will proceed with what is called ex parte hearing. And what an ex parte hearing is, one side gets to make their statements or their arguments, and since you're not there to defend it, you have no defense. If you ever have to try and appeal their decision at a later date, the court will not allow you to do that because you didn't even have the decency to show up in the first place. The second problem with not showing up is the simple fact that you have no idea what went on. Now, it's a safe bet that you got railroaded because you didn't show up. However, because you have no recollection and no way of knowing what transpired, you can't ever testify in court as to what took place because you weren't there. That would be called hearsay evidence, and it's inadmissible in all courts. And it says, please note, attendance at the court's hearing is by telephone. This is another repeat that is false. You have the right to attend a hearing in person, and I strongly suggest you assert that right. It says to arrange this, you must contact the counsel no later than 12 noon on the day before the court date shown on the summons. And it gives a phone number. The counsel will be able to respond to any queries that you may have or arrange a date and time for you to join a court hearing by telephone if necessary. Well, I've already explained it is necessary, and I've already explained that you should not do this by telephone. It says to discuss the summons, you must contact counsel and not the court. Well, if this is a valid summons issued by the court, you should be contacting the court. Since when does a party get accused of something and then have to contact the accuser to deal with the appropriate paperwork and the like? This is not standard court procedure. Typically, when you have a court hearing, you will, if it was a real court, you would contact the court, and you would also contact the, in this case, counsel, and you would file documents with the counsel, and then you would file a duplicate copy with the court along with a certificate of service in the UK. The very fact that you're discussing this with counsel and not the court is a surefire indicator that this is not a valid hearing. Further, the document which accompanies this, which is the so-called summons, does not have a court file number, and as such there is no record within the court. I have also contacted the Lancaster City Council, and they have advised me that the council makes use of the court, and the court acts on behalf of the council. However, these hearings are not recorded, and there is no file number, so it is not a valid hearing. It says challenging council tax liability order. What the council must prove to make a liability order to the council must give evidence that there's a current entry for the property of council tax banding list, which there is because all property fits in there somewhere. And then it says not a valid defense to a liability order to say you do not agree with your council tax band. Well, I would argue the point, well, what if their council tax band assessment has an error in it? Maybe somebody typed it in wrong. Maybe it's got an extra zero. Or maybe, as in one case, the person just moved into the property, and as such, they're not liable for the tax for the entire year. They might only be liable for the tax for 1 month. It says, but you can appeal against your band to the validation office at voa.gov.uk. If you are successful, you'll receive a refund on your payment. Well, they're telling you right now that you have no argument that you can bring into the court. Next, it says the council has advertised that the council tax in your local newspaper. Well, I highly doubt they ever did that, and they never proved that to the court anyway. And then it says that the bill reminder has been posted to the correct address. That is also incorrect, because what if you were in a hospital? Or what if you were away on vacation? Then it would be a valid defense to say you didn't receive it. And they're telling you it is not a valid defense to say that you didn't receive it. Just that the council has to prove that they sent it to the correct address. Well, as I indicated earlier, and I do know of one case where a person moved into a property and they're receiving the other tenants or the other past persons tax bill. Now it says they have to prove that you didn't pay council tax or any part of it. If you paid the council tax but not the costs, the council can still ask for a liability order and use it to collect the cost. Well, this is also incorrect because there is very little costs incurred in submitting a notice for a hearing into the court. It's all done electronically through software, and basically it's nothing more than sending an email. And a lot of times they are seeking costs of, 30 pounds, 40 pounds, 70 pounds. There is no set rate. However, if you look at the legislation, it's not supposed to be any more than, I think, 30 pence. So when you get that document, that's further evidence of fraudulent misrepresentation. Now, it says if the magistrates decide that it is likely that these things are true, they make the liability order, which is incorrect because they have to prove, the municipality or the council would have to legally prove that you're liable to pay council tax. And because the local municipality is in fact a corporation, some of which have a Dunn's number, which is a Dun and Bradstreet number. If you look up the Clearfield Doctrine, it says if a person operates with species of money and basically is a corporation, it has no more authority than any other corporation. So I would ask the question that if you don't work for Tesco, how can the rules for Tesco employees apply to you, because Tesco is yet another corporation? The same for Sainsbury's or any other corporation. Okay? There are only two reasons why the court will not issue a liability order. So this is telling you now that they're limiting your defense. The council has not done the thing that they're supposed to do in the top 3 bullet points above, or you have paid the amount in full, including costs. So they're telling you right there you have virtually no defense. So they've now limited your potential defense to nothing, and as such, you're being deprived of due process of the law. And given that fact, this is not a valid hearing. It goes on further to indicate magistrates cannot consider the following questions: whether the council was right to order you to pay council tax on your house. Well, certain properties are, in fact, tax exempt, and they have not proven that you're liable to pay council tax. So, again, this is another admission that you're not going to get a fair trial. Whether you should pay the tax is another thing they won't look at. So, okay, if they're not going to look at that either, so they're telling you that the municipality does not have to prove that you're liable to pay council tax. Well, I would argue that yes, they do have to. There's a legal maxim in law that says he who asserts must prove. Now it says on the third line down whether the amount claimed is wrong. So if council tax makes a huge mistake, you can't even address that in the court. So what kind of Mickey Mouse Clubhouse court is this? And then it says whether or not you should get council tax support, because there are certain people on disabilities and whatnot which do get a tax break. But the council tax, even if there was a mistake, as it says in the one above, and maybe you're supposed to be exempt, the council won't even look at that, and nor will the court. Whether the council tax support has been worked out correctly. So again, this emphasizes what I said earlier, that if there's an error, the court doesn't seem to care. It says you can appeal these 3 questions to the building authority or tribunal, but you can't raise them in a liability order hearing. Well, if you've already tried to talk to your local council by way of a letter or notice, and you're not receiving any sort of satisfactory response, and you can't bring this into a court because they won't listen to anything, all they care about, based on my experience, is did you receive a bill, do you live at that address, and did you pay it? Everything else is ignored. So you tell me how that is a valid court hearing. I can tell you for a fact that it is not, because he who asserts must prove. They won't even let you address errors. They won't let you address anything. They're having their court hearings in private, and they're fraudulently invoicing people for more than the statutory 30 pence allowed within the legislation. So one could argue that that's a problem. This is just a short summary of potential things that I see wrong with this specific document, which came along with the summons. And when the court was asked to provide a actual liability order from the court, stamped by the court, they refused to do it. The correct process for a liability order, if the court was to actually follow the rules, is the court is supposed to have a magistrate or judge look at your court hearing liability and see if the council is in fact correct in its assertion that you owe the council tax, and it's supposed to be reviewed on a point-by-point basis, not just a blanket email submission of maybe 800 cases or something in one submission. That is not on a point-by-point basis, and so there can be no underlying circumstances evaluated, and the person did not use logical thinking or their mind when they just said, yeah, okay, it becomes liable. And generally, from what I've understood and from the FOIA requests that I've reviewed, it's actually done by a legal advisor. A legal advisor's position in any court is to advise the court of legal arguments that may be to the council's benefit, but also to provide legal arguments that may be to your benefit. As a representative, they're not supposed to try to mislead or misdirect the court, and they're also not supposed to commit perjury. Now, in many trials, the legal advisor is actually conducting the hearing, which is yet another violation. And because the court has confirmed, when they spoke with me, that the court acts on behalf of the city council. Well, the court is not supposed to act on behalf of the city council. The court is supposed to be an independent judiciary to evaluate a case based on its merits. So based on that statement from them, they're already operating well outside the legal parameters that are required. And then if you ask for an appeal from the court, which is another avenue that you can go through, generally the same legal advisor who railroaded you in your first hearing reviews the documents and simply states no, at which time you have to appeal it to the a higher court. Basically, it's a high court in the administrative division. The other issue with this whole process is that you're not allowed to enter any sort of a defense, as I stated earlier, but more importantly, the legal advisor is running and conducting the trial, and there is no presentment from you which is permitted. There is also no cross-examination of any of the city council staff who are asserting that you owe this, and it has even been stated in certain cases that your council tax does not pay for any product or service. So if it doesn't pay for any product or service, then why am I paying council tax? The other thing that the viewer may wish to do is look into the expenditures of their specific municipality, either through a FOIA request or by simply searching the internet. And if you find that your municipality is engaged in unlawful activity, then you can't knowingly aid and abet a company or an individual that is misappropriating funds or funding acts of terrorism or like, which would be yet another argument against council tax. Every council tax case is different. Everyone has different parameters, different documents, different paperwork, and I do not suggest that anybody simply stop paying council tax. You have a right to question the legality of it, and you can write a simple, letter or notice requesting a billing error dispute, you could call it, and you could say, I don't see how these calculations are founded. The municipality never gives you a cost breakdown as to what your funds go for, and quite often when you bring this issue up, they say, well, we've given you sufficient information. Well, that's sufficient in their eyes. It may not be sufficient in your eyes, and it may not even address the questions or expenditures that you questioned. So if you ask for black and they give you brown, well, we gave you something sufficient. That's pretty much what it comes down to. So that would be yet another issue to deal with. We have, as I said earlier, the preliminary documents, which I go through all of the different statutes and appropriate sections that deal with the legal arguments against council tax. And because if you're now at the stage where you're receiving the summons to appear in court, this document will hopefully help you analyze the document which you received from your counsel and help you tear it apart and analyze the crap out of it and potentially have additional arguments which could be used against council tax. If you are not successful in your initial hearing, then you are going to be in a position to ask for an appeal, and there is a fee involved in that. And if they turn that down, your next option, of course, is to appeal it to the High Court Administrative Division. There's specific parameters and specific things that must be done in that case. And those proceedings generally follow standard court procedure. And if there's any questions regarding this, of course, everyone now has my email, and you can send me questions. I'm not going to spend hours and hours for free to give you information, but if you need a general, guidelines, I will try to point you in the right direction. This presentation has been a short presentation brought to you by Denied Truth, and we can be reached at deniedtruth@yahoo.com. And I also provide the link here for the Telegram group, which has now been expanded to deal with basically Denied Truth Global, deals with issues that are around the world that are common to a lot of people. There's a separate Denied Truth UK with specific topics for each thing. And we have done the same for Canada, and we have done the same thing for the United States. As time and resources permit, we will be writing out additional presentations, and there is also a YouTube channel which has been posted there too, and these presentations are linked there as well as in the YouTube channel, and will be also getting transferred over to Rumble and other social media platforms to hopefully have a backup in case something happens to one of the feeds. At least there will be a backup feed for everybody to get access to this information. I thank you for your time and look forward to bringing you additional information. If you have a specific issue you wish to have addressed, please make it known at the deniedtruth@yahoo.com web address, and I will see what I can do about helping you. I do not generally post anything unless I have walked the walk and talked the talk and actually went through a process, unlike many people who give you a partial solution or advise you of a problem and don't provide any real solutions. Whereas what I try to do is I try to show you the law and guide you in a way that maybe you can use it for your specific situation. Thank you.